guilt to the offense of coup d'etat. The trial court said that since it was its finding that Senator Trillanes in fact filed an application for amnesty, then it follows that his admission of guilt, no matter how general it may be, as well as his alleged recantation of any inconsistent statements, has also been shown. So to that extent, the court said that it would be, or it was denying the DOJ's application for the issuance of an alias warrant of arrest and a whole departure order because of the findings, of the factual findings that the court arrived at after a series of hearings and after admitting all the evidence submitted by both counts. All right, so essentially that was the tenor of the order of Branch 148 of the Regional Trial Court in Makati. You will please note that these factual findings are in direct contravention or the exact opposite of the factual findings of Branch 150 of the same court in Makati, where the rebellion case is pending until the present. All right, and so we are now confronted with a situation where two branches of the same court have different factual findings. Although in the case of Branch 148, it went further by saying that Proclamation number 572 issued by President Duterte is valid and constitutional. All right, so I'd like to inform everyone that this is not the end of it. All right, to some extent, both parties were successful. All right, DOJ insofar as its contention that Proclamation number 572 is valid and constitutional. All right, on the other hand, also on the part of Senator Trillanes, the ruling was in his favor because of the factual findings of the trial court. So we expect that both parties, of course I'm talking on behalf of the DOJ, may elevate this ruling of the RTC to a superior court. All right, on the part of Senator Trillanes, he may probably question that part of the ruling which stated that Proclamation number 572 is valid and constitutional. On the part of the DOJ, will probably question the appreciation of the evidence by the trial court Branch 148. So this is not the end of it. Nobody can claim that he or it has actually come out as the victor in these proceedings. Remember that this is only one incident of a major case that is pending before the Supreme Court. The main case is in the Supreme Court, the petition for certiorari and prohibition. And in connection with that petition for certiorari and prohibition in the Supreme Court, the court, meaning the Supreme Court, said that there are factual issues that have to be resolved by the trial court level. So you know what happened. So this was remanded, in a manner of speaking, to the RTC only for the resolution of the factual issues. But the main case in the Supreme Court is still pending. And this order by the trial court, whether of 148 or of 150, is not final. This is not the end of the proceedings. So if you have any questions, you may propound your questions now. All right, I will discuss the next legal move with our panel of prosecutors headed by OIC Prosecutor General Richard Fadulyon. All right, he's not here. I think he gave a lecture somewhere and he's on his way back. But as soon as he arrives, I will take up with him the matter of what legal steps will be taken by the prosecution panel.
So yung comment yung the fact that it upheld 572, but 572 itself had this provision sa dulo na ordering the arrest. Ano meron ba siya comment doon?
Well, that part, ordering the arrest, had been resolved insofar as the factual issues are concerned. So yung general principle of whether or not the issuance of Proclamation number 572 violated certain constitutional precepts like due process or interference with the authority or jurisdiction of the Supreme Court, and so forth and so on, that had been ruled upon by Judge Soriano in DOJ's favor. All right, but as to the nitty-gritty, our specific motion for the issuance of a warrant of arrest and a whole departure order, well, the factual findings would not sustain that kind of motion. So to that extent, parang hati yung kanyang decision. One in favor of constitutionality. However, the factual findings would not sustain the issuance of a warrant of arrest.
Sir Jay, aside from your MPD, yung decision ng both court ng 148 and 150, hindi po ba ito magdudulot ng talikuran? Kasi sabi niyo rin po kanina, the main case is at the Supreme Court.
Right. It boils down to an appreciation of the evidence, Essentially, pareho ng ebidensya yan eh. In both 148 and 150, essentially the same. But the appreciation by the judge presiding over the case may be different. Okay, so magkaiba sila ng tingin eh. So to that extent, parang confusing. But in the end, there will be a harmonization or a parang sort of a consolidated appreciation of all of this evidence. Maybe at the Court of Appeals level, or maybe even at the Supreme Court level. So kaya nga sinasabi ko repeatedly that this is just the beginning. This is not the end. Nobody has to claim total victory here. Okay? Umpisa pa lang ito. Marami pang pupuntahan itong kasong ito.
Sir, since dalawang korte na yung nagkakilala doon sa pwede na po kaya itong giveaway for court martial? Yes,
I'm sorry. Your question is whether court martial may proceed. I cannot answer that question because that's really that matter belongs to a different jurisdiction altogether. So I leave it up to the DND, the armed forces, the court martials to determine what course of action they should take after this one.
Can you give us can you educate us about the prospective criminal cases? Kasi one of the quotation of Judge Soriano prescribed the law.
No, what he's saying is yung dismissal of this case in 2011, the coup d'etat case, precisely because merong amnesty that was extended to the accused at that time. No? So on that basis, dismissed. So the question now is, did that dismissal attain the level of finality and therefore could not be reopened anymore? All right, so sabi ni Judge in his order, it seems that he has no reason to deviate from the general principle of immutability of final judgments, meaning he cannot really say, he cannot alter what he believes to be a final judgment already in 2011. However, in the same decision or in the same order, he actually said something like this, which gives me the impression that he believes that the principle may be subject to certain exceptions. All right, he said, meanwhile, the law is vibrant. Jurisprudence is its lifeblood. Subsequent jurisprudence may forge new horizons in which exceptions to the immutability of a final and executory judgment may be born. So he's harboring that possibility. He made this ruling because he had no jurisprudence to go by. All right? But he knows that his ruling will not stop with him. And this issue will be elevated all the way up to the Supreme Court. And there is that possibility that the Supreme Court may say that if the basis for a dismissal of a case was based on a void premise, then that judgment or dismissal is void. All right? And therefore will reopen the case automatically. That is a possibility that the judge himself considers as real. It's not always the case that whenever you appeal, must back up your arguments with decided cases. It's not always the case, because there will always be a first time where a new and novel issue will be presented to the Supreme Court, and you give the Supreme Court an opportunity to make a watershed ruling with respect to that issue. You give the court an opportunity for the first time to forge a new judicial principle.
Sir, at some point in the decision, the judge even said that he had lost jurisdiction after it's become finally says. Sir, from what we've seen, what you've seen so far, do you think it's worth the government's time to continue the case before this judge, or should we go out?
No. With respect to him, we're more or less done. Okay. All right? Because he and Branch 150, 148 and 150 were simply directed by the Supreme Court to resolve certain factual issues which are incidental to the main case in the Supreme Court. So we're done. We're done. However, ano mangyayari dyan? No? Looking forward. Kung sakali that the Supreme Court in the end will say that that there is basis to reopen the case because the dismissal in 2011 was void, being premised on a void assumption of amnesty extended to the senator. All right, what would that happen? The cases will be reopened. In the case of the coup d'etat case, what will happen? Trial in that case is over. And what is left to be done is the promulgation of the judgment. All right, so this case may go back to 148 for promulgation of the judgment because trial is already done. In 150, trial will still start, no? So pagka na-reopen yung 150, then both parties will present their evidence therein.
Sir, mayroon kasi naging decision si Judge Soya about the two soldiers na hindi nag-avail ng amnesty. Sa Court of Appeal sila, they are guilty of the COVID in the Judge Soya, but when they appeal their case at Court of Appeal, it was reversed.
All right, yeah. So what does that mean? That in the trial court, no, two guys similarly situated, all right, were actually convicted. However, they appealed. And on appeal, ni-reverse ng Court of Appeals yung judgment of conviction against them. All right? Okay, but they're not exactly on the same footing as Senator Trillanes. And why is that so? Because Senator Trillanes was an acknowledged leader of d'etat. The two were merely followers. Nonetheless, they were convicted by the trial court. However, pagdating sa Court of Appeals, ni-reverse. Maybe because they were simply following orders. We don't know. I'm not too familiar with that case. But what I'm just saying is, this is not exactly the same as Senator Trillanes' case, who acted as leader of the coup d'etat. Yes, please go ahead.
Sir, how would you reconcile this decision of the judge saying that Presidential Proclamation 572 is valid when the basis of it stated that Senator Trillanes did not apply for amnesty and did not attend equal recovery? So how would you reconcile it?
I think he should be the one to reconcile his own ruling, you know. But we're happy to say to find out that he's saying there's nothing unconstitutional or invalid about Proclamation number 572 because that was in the exercise by the President of his power of control and supervision over the executive department, no, and that also impinges on his authority and power to grant executive clemency. So that matter squarely falls within the powers of the President. However, in this particular case with respect to Trillanes, Senator Trillanes, I'm sorry, ay hindi naman napakita na meron mali doon sa kanyang pagkakabigay sa kanya ng amnesty. So, yun lang naman yung finding, but that is not final, as I repeatedly say, no? That is not yet the final finding because this may be subject to a review by the higher courts. Anything further? All right, clear? where we are headed. Okay. Thank you very much for your time.
Both parties were successful from that ruling of Makati RTC Branch 148. That's according to DOJ Secretary Bernardo Guevara. Guevara claims success on the basis of Judge Soriano saying Proclamation 572 was valid and constitutional. He did, however, say that the Trillanes camp can also claim a win on no arrest warrant being issued, and that the factual issues that have been resolved in favor of Trillanes there had been sufficient evidence, and that he did file for amnesty. He says this is not the end of it. It's actually just the beginning of where this matter can go. This is just one incident of a case at the Supreme Court. He also said that future legal steps will be taken up with Acting Prosecutor General Fadulyon when he returns from official business. He leaves it up to the DND, the AFP, and the court-martial as to what steps they are going to take after this decision by Branch 48. He noted, though, that though Judge Andres Soriano did say that he cannot overturn a decision that has been deemed final and executory, a line in his decision gave some room for any possibility in the future for having cases overturned. That line reads, subsequent jurisprudence may forge new horizons in which exceptions to the immutability of a final and executory judgment may be born. Secretary Guevara is saying this is his basis for saying that this is not the end of it. It can still be overturned. Okay, we're turning to Attorney Gil Aquino of the Center for International Law on his view on the ruling of Judge Andres Soriano of Branch 148. Attorney Aquino, you were talking about the two rulings and how two courts have different decisions on the same set of facts that were presented to them before we got cut.
Yes, and I think Justice Guevara was also touching on this. How can two judges with the same set of facts, evidence, rule differently? I don't think, for one, I don't think they were given the same set of facts. I think Judge Soriano was more exhaustive, and the proceedings there asked more questions to the witnesses as to the circumstances about the filing of Senator Trillanes, right? But again, as I was saying, they're two different human beings, and they appreciated evidence differently. But the main difference, I think, in the decision is not so much on the factual issues. I think the more interesting aspect is the statement of Judge Soriano, where he said that even if Proclamation 572 is legal, he has no power to overturn it. That is the more interesting legal issue for me.
Right, but as I just reported, and as the Secretary mentioned, that he is claiming that this is still not the end of it, and he quoted that line from the decision, that basically saying that the Judge Andres Soriano himself was saying there is room in the future, there is still that possibility in the future that this can be reopened. Your thoughts on that?
Well, interestingly, also Justice Guevara said that this is a novel case. He kind of admitted that there is really no case that supports his position strong. It seems like he's banking on the Supreme Court having the power to issue new rules for novel arguments to support their position. I think, though, that it is true that it's not the end of it, but it doesn't look good for the DOJ, for me, because the ruling of Judge Soriano is a ruling that is legally sound when you read it, and the Supreme Court can just follow his line of thinking. His line of thinking is that Proclamation 572 is legal and constitutional, which is fine. But that in itself does not solve the question or answer the question about whether or not the decision of the RTC dismissing the case of Senator Trillanes in 2011 can be overturned. Does the regional trial court even have the power to entertain this kind of motion? And can even the Supreme Court reverse or touch a decision that has been final and executory for 7 years? So that is the main legal question that the DOJ now has to overcome. And I think the Supreme Court can do well in just following the logic of Soriano and come up with a sound judgment.
Right, I was going to ask you that. Now, with this ruling of Judge Andres Soriano, could this ruling give Senator Antonio Trillanes a better chance at a motion for reconsideration at Branch 150? Can he use this for his motion for reconsideration at Makati RTC Branch 150?